This is something difficult to think about. An elderly loved one going into declining health due to Alzheimer's or an advancing dementia. But it's something that you really may need to prepare for because you may have to handle their financial and health decisions. Joining me is Robert Slutsky, an elder law attorney from Robert Slutsky Associates. Robert, you said that there are two ways that we need to manage our loved one's care: through asset management, also through healthcare management. So tell me about the two different approaches that need to be taken.
Well, first, the think ahead approach is to have a durable financial and or healthcare power of attorney in place. What we're looking here is continuity of decision making. We want to make sure that when someone no longer has the capability to make decisions, that somebody can step in relatively quickly and do that for them. With a healthcare power of attorney, we're looking at two types of decisions. The first decision is when someone is mentally not in such good shape, they have dementia, they have Alzheimer's, or some other reason why they can no longer make decisions, but they may still be physically reasonably healthy. We need to have someone and a means of having someone come in and make those healthcare decisions. The second part of the healthcare power of attorney is typically what most people know as a living will or an advance directive, and that deals with decision making at end of life, whether someone wants heroic measures or how they want to die with dignity. On the financial side, we want to talk about a financial power of attorney. And like the healthcare power of attorney, we want it to be as broad as possible. So we want to have a document that allows the agent, the person who's given the authority to make decisions, to be able to do lots of different things: access bank accounts, sell stocks, bonds, or real estate, file tax returns, defend lawsuits, all kinds of financial stuff. And the goal here is to give them as much authority as possible, assuming that you feel that they're responsible to do that job. Now, if someone hasn't planned ahead, if there hasn't been thinking, or they simply don't have someone who they feel confident to make good decisions for them, then we talk about legal guardianship. And legal guardianship, unlike a power of attorney, is a court proceeding. It's actually not voluntary. A power of attorney is something you give away voluntarily and can revoke at any time.
Right, and so when is it appropriate, though, to go for a legal guardianship and to actually bring it before a judge?
Okay. For a legal guardianship, first of all, that's generally something we don't want to do in the beginning. We prefer powers of attorney. But a legal guardianship is typically under two circumstances. One, when the person is cooperative and compliant, but we've gotten past the point where they can really understand what they're signing, and we do it because we don't want to have someone who's cognitively impaired signing legal documents they don't understand. The second instance is in the unfortunate circumstance when we have an older adult who might have done planning ahead and already has a power of attorney in place, but because of their cognitive impairment has become difficult to handle. They've become aggressive. They've become uncooperative. Exactly. And in that combativeness, they might undo what their power of attorney has been doing to help them and keep them safe. So the idea of a guardianship is it's a last-ditch effort to protect someone.
So if you'd like more information on Robert Slutsky and Associates, just head to cbsphilly.com and click on the Talk Philly. We're coming right back.